like to introduce now Alan Schwartzseid from our Orlando office. Alan, tell everybody a little bit about yourself and how they can reach you, and then we'll get started.
All right, thanks, Jeff. So I'm going to share my screen real quick so you guys can see what we've got going on today. This is the course information. If you are trying to obtain CEU credits, you've got our information here. As Jeff mentioned, we've got offices in Orange County, Hillsborough County, Palm Beach. Our primary office, the main office, is in Broward County in Pompano, and we've also got an office in Miami-Dade that's available by appointment only. Now, as to who I am, why I'm here, I am the managing partner, as Jeff mentioned, of the firm's Orlando office. We're 21 lawyers. We all practice in the area of community association law. I actually got my start with the firm back from 2010 to 14, and went around and did a little bit of other work within the community association realm and found that there's really nobody better. And so here I am right back where I started in the industry. I rejoined the firm about 3.5 months ago, and I'm very happy to be here. Like I said, we have 21 attorneys, 9 of them are board certified in this community association practice area. 1 is board certified in construction law. As to who I am, I'm also a certified mediator for county and circuit cases. So that's a part of my practice, but I generally do a lot of the day-to-day guidance that communities offer. And that's why I'm probably one of the better choices. And there are many of us within the firm that do that. But we're all a good choice to be a presenter for this kind of class, because it really does cover a broad spectrum of everything you need. Jeff mentioned we've got almost 200 slides to get through, so we're not required to touch on every single thing. So there may be some things that I go really fast through. There may be some that I skip altogether. These materials will be available to you if you want or need them. So if we skip over something, don't think that that means you'll never get the information or that it's not available. If you're a client, you're always welcome to reach out. If you're not a client, we hope that after receiving this type of education from our firm, that you'll consider reaching out to me. And like Jeff mentioned, we made it as easy as possible to contact me. I used to have Schwartzseid@kbrlegal.com. That got a little cumbersome. So when I rejoined the firm, they were kind enough to say as@kbrlegal.com is my personal email address. If you want to reach out to me, you're welcome to do so at any time. And again, if you're not a client, we welcome you to reach out to make that change. So that's why I'm here. That's why our firm is here. But let's get into why you're here. So board member certification. Within 90 days after being elected or appointed to the board, regardless of which one it is, you as a newly appointed director need to either sign a certificate that basically says, oh, I read all the governing documents, I'm going to try and uphold what's in there, and I'm going to faithfully discharge my fiduciary duty to the association and to the members. Now, you can do this up to a year in advance of being a member of the board. The better way to do it is what you all are doing right now. You can attend a class like this and not have to certify that you read your governing documents, not have to certify that you understand what's in there, which, let's be honest, most attorneys and judges don't understand what's in there. So I think that you guys are doing the right thing by being at this class, by getting that certificate that says, I acknowledge that I'm not all-knowing and I don't understand all this stuff. The people that sign that certificate are pretty much opening themselves up. When I say that certificate, I mean the one that doesn't say I came to this class. They're opening themselves up to being questioned about how much they actually understood in those governing documents. And I've had in the past experience where directors sign that certificate, and that was the first thing that was presented in their deposition testimony in a lawsuit that had nothing to do with these association issues, but it was a way for the other side, the owner, to prove that this person had signed a certificate, basically verified, I read all this, I understand what I'm supposed to do. And of course, this person had no idea what was in those governing documents, or had an idea of it, but wasn't able to articulate it because, well, neither could I most of the time, and neither could most attorneys and most judges, like I said. So you're in the right places is what I've just spent a lot of time coming out and saying. The certification does not have to be repeated as long as the director serves without interruption. Without interruption means if you come off, If you're suspended, you might have to do another class. If you come off the board, I actually just had this come up within the last week or two. I had a director who had been a director. She had been the president of a community in Brevard County for, I think, 5 or 6 years. And she came off the board, came back 3 or 4 years later, and is now the president again. And I'm hoping that she's here in this class because she would not have been able to rely on that prior certification to still be certified. Okay, so a director who doesn't do this, in other words, doesn't either sign the certificate that I think is a bad idea, or take this class within those 90 days after first joining the board or rejoining the board, whatever it may be, that person is automatically suspended from service until they complete this requirement. When I say automatically, I mean it doesn't take a vote of the members. It doesn't take a vote of the board. It doesn't take a board meeting. It happens by operation of the statutes. So be careful. Make sure that if you've got other people on your board, send them to a class like this, or at least have, as a temporary measure, have them sign that certificate and then take this class. And maybe you can't remove the certificate, but at least supplement it with, hey, you know, I did that just to make sure I read all the governing documents. I attested to what I needed to attest to, but now I've also taken the class, so I'm doing the right thing, at least from one lawyer's perspective that I know of. Okay, now this written certification must be kept for 5 years after the director is elected, or the duration of the director's uninterrupted tenure, whichever's longer, meaning up to 5 years if it's only, let's say, a 1 or 2 year period that they're on the board. If they're on the board for 8 years, because, for example, no one else steps up and wants to be on the board, you need to keep these things indefinitely until they're off. Okay, not having this certification doesn't affect the validity of board action. So if you didn't know that this person was supposed to be suspended for the last 6 months, but they still voted on things, made motions, seconded motions, etc., they still acted as though they were a valid active director. That doesn't impact whether or not anything that you did during that time is valid. So the board votes remain the board votes. Nothing is rescinded automatically. You don't have a problem, but get it done as soon as possible. And again, I'm going to apologize. There's going to be a lot of times that I speak way too quickly, but we've got 186 slides to get through and we're only through 4 so far. So I'm going to apologize this one last time, but just understand I'm trying to get through everything and hopefully reach some of your questions for question and answer at the end. All right. Condominium.
Too, this is being recorded, so if anybody needs to refer back to it later, they'll have that opportunity as well.
Thank you. Good point, Jeff. I appreciate that. So if you need to listen to this 5 or 6 times to get what I'm saying, go ahead and do it. I appreciate that point. So condos only exist because there is legislation that says they do. Whereas an HOA, generally you had a declaration that was created and recorded, and they already were subject to, nonprofit laws, which is Chapter 617, which we mentioned here as well. Condos only exist because the legislature said, yeah, that's okay. So keep that in mind. The declaration of condo creates your title. It also contains all your covenants and restrictions. The condo wouldn't exist without the statute or the declaration. All of the owners in a condo own an undivided interest in the common elements. And now I know we have a co-op person here, so I'm going to throw a little bit of co-op knowledge out there once in a while if there is a difference that is very obvious. In a co-op, everyone owns shares in a corporation, and you only get a proprietary lease for your unit or your parcel. In a condo, which is what we're technically here for, everyone owns an undivided interest in the common elements, and they own their particular unit. You might also own what's called limited common elements, or at least have the only person in the condo that has the right to use those limited common elements. We talk about material alterations. That means you're changing the way that something in a condo looks from the outside of the units. Typically, the board can't make those changes without at least a 75% approval of the unit owners. Now, you might have a lower percentage stated in the declaration. If you have that lower percentage, great. It's an easier vote. If you don't, you can amend to change that percentage in the declaration so that you can have a smaller vote. Okay, powers and duties of the board. The association operates the community and maintains the community. That's pretty much it. Everything else derives from that. Okay, you can institute, maintain, and settle legal matters, in other words, potential or existing lawsuits, on behalf of all of the unit owners. concerning matters of common interest, meaning if it's something that impacts the entire condo, the entire building, all of the common elements, etc., not just one or two units, the association can settle that on behalf of all the members. The association has all the powers granted to corporations, except as Chapter 718, which is the Condominium Act, 607 and 617, which are the corporate statutes, or your governing documents, your declaration and others that we'll get into in just a minute. If your governing documents say you don't have the power to do something, you don't. If the statutes say you have the power and the governing documents say no, those governing documents might control because they are more specific, they're more narrowly tailored to your particular community in the way that your people, whether that's the developer or if you've amended after the developer gave up control of the community, wanted that community operated. And when I say community, I really mean the condominium. Okay. The general grant of power to a corporation includes a whole bunch of powers that, like I said, we don't have time to go through, but you've got that in your materials if you want to read through it all. Which year's statutes apply? That's where I said you might need to look a little deeper. It's not just, well, the declaration applies all the time or the statutes apply all the time. It may be, okay, well, the statutes apply in this situation. Which year's statutes are we talking about? Is it the substantive law in effect at the time of the contract? In other words, when the declaration was first recorded? Well, that's technically grafted into the contract, the declaration, which is a contract, by the way, between all of your members and the association as a corporation. Okay, it's as though that statute were expressly written into the entire contract. There is constitutional protection both on the federal and Florida state level from retroactive application of laws that change your rights in certain ways. Okay, if it adversely affects or destroyed a vested right, that's not a theoretical right, that's a right that you already had. Okay, or if it imposes or creates a new obligation or duty in connection with a previous transaction. In other words, we're going back on something that's already occurred or that imposes new penalties. Okay, in other words, unless this certain language that's called Kaufman language is in your declaration, chances are new statutes might not apply to your community. Okay, if the declaration does say that it's subject to the Florida statutes or the Condominium Act or any other thing that pertains to the Condo Act, as amended from time to time, you'll see this bold capitalized language. Those are the magic words. They're called Kaufman language. If that's in your declaration and it refers to the entire Condo Act or a specific aspect of the Condo Act, then each year's legislative changes pertaining to that issue or the act as a whole, they will apply those changes as though those changes were included in the declaration originally. Just like when we first said earlier, the substantive law in effect at the time of the contract, we treat it as though that law is what was intended in the contract because of this language. We're basically saying, listen, we know that statutes change. So we're going to incorporate those changes into the declaration and into the way that our community is going to be governed. Okay, this is an analysis that your lawyer will probably have to do. But if you can look out for it, then you might be able to figure out, at least to some extent, because this is a complex issue, which year's statutes might apply. Problem is, you then need to interpret that year's statutes. So this is not an easy analysis. Frankly, most lawyers get this wrong in my experience. Okay, so just keep all this stuff in mind. I'm mentioning it all because you might need to keep in mind when you're asking your lawyer, it's not just does the statute apply or does the declaration or the bylaws or the other governing documents apply. It's which statute, whether it's the statute or not. If the declaration doesn't include that Kaufman language, then a careful analysis that I just mentioned needs to take place. Does the legislation itself say that it's retroactive or not? If not, it's generally not retroactive. At least that is the way that most people interpret it. If it doesn't expressly say it's retroactive, it's probably not. If there's nothing that says it's retroactive, are the changes substantive, meaning they change a substantive right that you already have, like we mentioned above, under this constitutional protection item, or are they procedural? Procedural means we're changing how you run an election. We're changing how you pass a budget. Procedure, okay? And it's not that simple, even though I'm trying to make it that simple. So just keep in mind, if it's procedural, the new legislation applies. If it's substantive, then the constitutional rights are going to kick in, and you probably won't be able to change what the previous statute said. And you'll be stuck with the original statute unless and until you amend to expressly say this is the statute that applies, or you incorporate specific language that equates to what you actually want to apply to your community. Okay, which year statute apply? We already discussed procedural versus substantive laws. And this just gives you a couple more examples of what is procedural versus substantive. Okay, conflicts between the declaration, articles, and bylaws. Okay, we're going to go through what are these things in the first place. The declaration is your covenants. It is the constitution for your condominium. It's a contract, like I said, that binds your members and the association, and it runs with the land. In other words, everyone that buys a unit, generally speaking, the declaration is going to be referenced in the deed. Okay, this declaration necessarily comes before anyone buys a unit in your condominium. What that means is that the declaration is actually a higher document. It's considered superior to your very deed. And that's why when people say, you can't tell me what to do with my property, the answer is yes, I can. And here's why. Because my declaration that gives me rights and obligations was recorded before your deed, and therefore you were considered to be on notice of everything that's in that declaration, as well as the fact that that declaration could be amended, just like any other declaration of condominium, declaration of covenants, etc., throughout the state. Okay, it's basically presumed valid. Everything in there, by the way, is basically presumed valid unless it's arbitrarily enforced, or there's case law that says, for example, you can't have something that says that a certain race is not allowed to live or buy in your community. Okay, there are certain things that case law has said you can't have. Everything else, even if it's unreasonable, it's allowed in your declaration. Okay, this is a contract that everyone basically signs without signing by buying property in your community. The articles of incorporation state the name and purpose of the corporation itself. Okay, so you may have limitations on what you're able to do as a corporation within those articles. Don't ignore them, even though they are pretty much just a form. Some communities I know have incorporated a lot more than just that form into their articles of incorporation. And then finally, you have the bylaws, which are generally going to be what most people think control the day-to-day operation, but they really control how meetings are run, who the directors and officers are, and what their responsibilities are, etc. And then finally, you've got rules and regulations. Generally, they're board made without member approval, which means that they're scrutinized really closely by courts. It's not a presumed reasonableness when you're talking about rules and regulations, because the members themselves didn't get to vote on these things. It's the board presenting these rules and regulations. Okay. So declaration, articles, bylaws, that's an easy way to remember the governing documents. And I'm a little young for the little dabble do ya, but I do know what it's all about. So just keep in mind, declaration, articles, bylaws, those are going to be your main documents. And then you've got, if you have a land condominium, you may have architectural standards, you might have rules and regulations in any condominium, etc. Okay, now we're going to talk about what happens when someone sells or tries to refinance a unit, or frankly, if they just want to know what they owe and they don't think that a ledger is good enough. So they might ask for what's called an Estable Certificate. Let's talk first about condominium association transfer fees. You cannot charge a transfer fee, which is in connection with sales, mortgages, leases, subleases, any other transfer, unless the association needs to provide approve the transfer, and is allowed to charge that fee pursuant to the declaration, articles, or bylaws. What that means is, if your governing documents don't say you can charge for that, even though they allow you to screen, which is what we're talking about when it comes to approval, even though you can screen these purchasers and tenants, if it doesn't specifically say that the members have approved that you can charge a transfer fee, you can't charge one. Okay. That fee is capped at $150. You can't charge it for renewals of leases or subleases at all. So if it's a renewal rather than a new tenant, or let's say it expired, they left, they came back, you might be able to charge a new $150 fee in that instance. You can require a security deposit if it's required or authorized in the governing documents. But the question then that I've dealt with in the past involving via a lawsuit is, Do you then become a landlord once you demand or accept that security deposit? The answer was no in that case, because I successfully defended the association. That doesn't mean that all judges are going to say, no, you're not a landlord. Now, I don't think any judge should find it, but you never know what's going to happen in litigation. Then the other question becomes, who gets that security deposit back afterward? Is there something specifically in your contract, which, by the way, there should be? Put it in your declaration. Here's the person that gets this back at the end of the lease. And the security deposit is not for damage to the unit. Let the owner that actually is responsible for maintaining that unit deal with a security deposit under the lease. What you're talking about is for damage to common elements. Okay, so you don't really care who gets this back. You just care, and I'm telling you, you care, that there is something in the declaration, the bylaws, wherever you have your provision that says that this security deposit is required. Make sure there's something in there that says who gets it back at the end. Because, pardon me, I'm also getting over something. So I apologize if I cough and take a sip of water. So the question of who gets it back afterwards, that's actually another thing that has been the subject of several lawsuits I've had to deal with on behalf of communities. And what we did was we basically sent the money to the court, filed a lawsuit and said, Judge, you decide who gets it. We don't care. We just don't want to get sued for giving it to the allegedly the wrong party. And what ended up happening is we ended up spending more money than the association got as a security deposit in every single instance, even the one where it was $3,000. Because we ended up having to file a lawsuit. The parties were arguing about it. So not only did no one get that security deposit back, but the association ended up out of pocket, which I think is a bad idea on something that could be easily addressed by just including something in your declaration that says, here's who gets it. If you don't have that in your governing documents, I strongly suggest an amendment to make sure it gets in there. Okay, these Estable certificates, you have 10 business days to provide the Estable certificate itself. The document, and we'll go through very briefly, but it basically says what's owed on each account that the estoppel was requested for. It also includes other information that we'll go through in a minute, but you have to supply the document itself, which is something that the association creates, or in some instances, a title company or a lender will actually send over a form that they just want filled out. Make sure that the information they're asking for is in the statute if you're the one filling it out, whether you're a manager or a director. Because if you don't have to provide that information, yeah, you may want to anyway, but you may not be obligated to under the statute. So just be careful that you're not sending out information that technically these people are not entitled to and that maybe they shouldn't have, okay? Keep in mind, anything that's not in this estoppel, the word estoppel is a legal term that means you cannot do something that goes counter to what you've done in the past. It's a little more complicated than that, but that's the basics. And what it means is that this Estable certificate is the most you can get at closing, which means that if that mortgage closes, if that sale closes and title transfers or the mortgage is funded, okay, after that, if you find, oh, we made a mistake, there's another $20,000 that this owner owes, or there was a violation we wanted to put on there and notify the new owner that they needed to cure it. Sorry, but you're probably out of luck because that's the purpose of this certificate. You're saying, here's what needs to happen at closing. And now there might be 50,000 other things that need to happen at closing. This is from the association's perspective. Here's what we need to see for this new buyer or this lender to not have any problems coming into the property. If the account is in collection, by the way, do not state what is owed on the account. Have your attorney fill out that portion or at least give you the information, because I've had instances, again, whatever's in here is all you get. And I've had instances where there is a big ongoing dispute and someone decides, you know what, I'm just going to sell my property rather than continue dealing with this foreclosure action. Well, we've got $10,000, $20,000 in attorney's fees because they've been extremely contentious. And all of a sudden that $10,000, $20,000 is no longer collectible because the association didn't ask the law firm, well, what do you guys show as being owed? Okay, so just be careful with that. That's for managers and for self-managed communities. Be careful. Do not prepare a payoff if this account or a violation potentially, depending on language in your governing documents, is with counsel. It's crucial to handle these things as soon as possible. If you don't provide it within the 10 business days, you cannot charge a fee for preparing it. So just be careful about that as well. I Okay, so these are just things that go into it. I'm not going to waste your time going through them in detail. Assessment information needs to go into it. There's other information that needs to go into it. And again, there are violations that might be stated, whether the rules are applicable to the property, that there are things being contemplated over the next 30 days, etc. So again, it's basically making sure that this person coming in is really going to not walk into a storm. I'm skipping the word before storm. Or that there is not a huge balance that they're going to walk in owing, etc. Here are the charges that you're allowed to levy for this Estable certificate. You can charge anything up to $250 if on the date the certificate's issued, nothing is delinquent. Delinquent basically means that it's past due. If there is a delinquency, you can charge another $150, and that's whether you use your attorney or not. So that's a total of $400. If the person is requesting a rush, that's another $100 fee, but only if you provide the Estable certificate within 3 business days after the date of the request. In order to charge an Estable fee at all, the association needs to actually have a written resolution that says that they are going to go ahead and charge it, or it needs to be included in your contract with your management firm. If neither one of those exists, technically you could be walking away from $500 per Estable and paying your attorney for preparing whatever their fee is, which is usually that $150. But you may be walking away from a bunch of money that you didn't need to spend or you could have collected. So just keep that in mind. If the association doesn't provide it within the time that's provided, that 10 business days after receipt, a fee cannot be charged for preparation. In other words, you lose that $500 or whatever the exact amount is. Now there are, another thing to mention that's important. If you don't provide the Estable certificate within the 10 business days, I've also seen owners claim, well, you lost me the sale and I'm going to sue you for damages for the lost sale, etc. I've never seen anyone succeed on it, but I've also never seen one of those cases end up at trial. It's usually settled, but I have seen them filed. And keep in mind, as soon as it's filed or as soon as it is threatened, you're either involving your insurance company, your attorney, or both, and you're spending money. So let's avoid that by providing the Estable within the time provided. There are fees for providing an Estable certificate for multiple parcels. I think they are woefully deficient, but that is not up to me. It's up to the DBPR what those fees are going to be and the legislature. So unfortunately, I don't get to decide what I think is a reasonable fee for this stuff. The state does. If it is, now here's another thing that's important: reimbursement of the fee. If this fee was paid and the sale doesn't close, and that's within the 30 days after the closing date for which the certificate was sought, not within the 30 days that's provided in the Estable, but within 30 days after the proposed closing date, even if that proposed closing date is 6 months down the road. If the preparer receives a written request accompanied by reasonable documentation showing that the sale didn't happen from a payer that is not the owner, the fee must be refunded to that payer within 30 days. In other words, someone paid your fee. They then said, listen, this didn't close. We're backing out. And it's within, a reasonable time after the back out occurs. You still need to provide those dollars back to the person that paid them. Now, that doesn't mean you're out the money. It just gets tacked onto the owner's account. And presumably as a cost, the statute isn't really clear. It may be an assessment. I think it's safer to treat it as a cost because the statute's not clear as to how it's supposed to be assessed. It says in the same manner as an assessment is the way to collect it. It doesn't say that it becomes an assessment, but I have seen communities treat it as an assessment. That right to reimbursement can't be waived, and the prevailing party in a lawsuit to enforce a right of reimbursement gets damages. In other words, anything that they laid out, the $500 that we talked about, or the max $500, and all applicable attorney's fees and costs is what they get back. So in other words, make sure that you're doing this the right way. You don't want to end up losing one of these cases and paying out $5,000, $10,000, $20,000 in attorney's fees for really no reason. Okay, adjustment. That dollar figure is changed every 5 years in an amount that is determined by the CPI for all urban consumers, US city average, all items. The DBPR basically calculates this. This was just done in July of 2022. So obviously we don't expect it to be changed much in the near future, notwithstanding any actual, we are seeing what is not being labeled as a recession, but is definitely inflation. And so just don't expect that to be adjusted for inflation, even if that $250, that $500 doesn't go nearly as far as it should anymore. The estoppel is good for 30 days if it's emailed or sent by hand delivery. If it's mailed, it's good for 35 days. I don't know anyone that mails them anymore. I think almost everyone will either fax, email, or hand deliver. If you find a mistake or you come across additional information that wasn't included in the original, you need to supplement by an amended estoppel certificate and make that amended version good for the same 30 to 35 day period. Not from the date the original was issued, but from the date the amended one was issued. Okay, and you can't charge a fee for preparing that amended estoppel certificate. You waive the right to collect anything beyond what's in the estoppel certificate if anyone relies on it in good faith and actually closes the transaction. Okay, so again, I know I said it twice. I want it to be abundantly clear. If it's not on there, you're not getting it, period. So make sure it's on there is the bottom line. Again, there are other things that the purchasers can ask for. You can charge up to $150 plus the reasonable cost of copies and attorney's fees incurred in responding to requests for information from a prospective purchaser, a lien holder, etc. The Condo Act provides special language to avoid liability. If that information isn't accurate, make sure to include this language that's stated here. This is really coming from Fannie Mae, Freddie Mac, other lenders where they want more information than what's included in the estoppel certificate. That's really where you're going to see this for the most part, but there is a specific statutory request that they can make. So just be aware of it. If you've got a manager, send it over to your manager if you receive it, and management, if you get it and you don't know what to do with it, reach out to an attorney. You might also, or you will also have a condo question and answer sheet that needs to be updated annually and must be provided to prospective purchasers by the association. And the seller does also have specific responsibilities in disclosing problems with the unit, etc. The seller also, and when I say seller, I mean the unit owner who is selling their unit, needs to give copies of the governing documents, financial information, and the FAQ sheet that I mentioned a minute ago to the prospective purchaser. Okay, so there should be no argument that this purchaser had no idea that your covenants govern the property. That purchaser is also entitled to receive a copy of a governance form, which is provided by the division, summarizing governance of condominium associations. That's more of a general form. It's not really condo specific, but it does include some specific information regarding your community. Okay, so this disclosure, in addition to the other information the division considers helpful to purchasers, all of this information is going to go into that form that I mentioned a minute ago. I'm not going to go into it, but it basically outlines how the associations run. It's like a baby version of what you guys are going through today, this type of course. Okay, and again, more information that's in the disclosure form. And again, this is in your material, so even if I skip it, don't worry about it. You can always just read through this later. And we will be supplying at least access to the materials to anyone that needs or wants it. Okay, moving on, use right suspensions, voting suspensions, and fining. I like some of this, I hate some of it, and we'll get into what that is in just a minute. So fining, you can fine or suspend use rights of a member or anyone else in the community after following this procedure, even if nothing is stated to that effect in the governing documents. The board votes to levy the fine or suspension. That's step one. Step two, you give 14 days notice of a hearing before a separate impartial committee. I'll let you know in a couple minutes who that may be. Okay. The question is, the statute isn't really clear. Are you required to hold that meeting or just offer one? My answer, just hold the meeting. Okay. You can do it via Zoom. You can do it very easily. Why take the risk? Okay. Hold that meeting. That is the fining committee meeting or fining hearing, whatever you want to call it, the suspension hearing, whatever you want to call it. But I would say hold that meeting so that at least there's no argument that you didn't follow proper procedure that's available to the owner to avoid the fine or the suspension. If that committee doesn't approve the fine or the suspension, the board can't do it. If they approve, then it takes effect and the board needs to give notice of the fine or the suspension. Okay. The maximum fine allowed in Florida for a condo violation is $100 per violation per day of continuing violation, up to $1,000 total per violation. You cannot lien for fines in a condominium, period. In an HOA, you might be able to, it's questionable, but we won't get into that. But in a condo, you cannot lien for fines. Okay. Now, here's who the fining committee can't be and why I think it's so extremely difficult to actually comprise a proper fining committee. Can't be an officer, a director, or an employee, or any of those three people's spouse, parent, child, or sibling. Okay, so it needs to be a completely separate unit. Now, in smaller communities, that's really difficult. If you've got 5 condo buildings, that might be a little easier if they're all operated as one joint condo. You know, that may not be so difficult, but a lot of the time it is. Keep in mind, these are usually the most hated people in your community because they're the people saying, yep, I think this person was wrong. Okay. Now, if they do it right, they're also the person hearing the person that is subject to the fine or the suspension, hearing them out. So it could go either way. Usually it is kind of a rubber stamp because no one shows up at these meetings except for the people that are required to. So just keep this in mind. Suspension is typically going to apply to common facilities such as pools, gyms, laundry rooms, clubhouses, rec rooms, etc. It does not apply, and you cannot suspend the right to access limited common elements applicable to that particular unit. For example, the balcony that's attached to the unit, common areas that need to be used to access the unit. In other words, the hallway, your elevators, etc. Utility services provided to the unit. So that's electric, water, in some instances, internet, if it's provided by the community, or your parking spaces. Okay, you can't suspend any of those things, just the facilities. Suspension of these rights to use the common elements and common facilities and the voting rights for non-payment of monetary obligations to the association for over 90 days. In other words, someone's delinquent more than 90 days must only be approved by the board at a duly noticed board meeting. In other words, you don't need to comply with that whole lengthy 3-meeting or 2-meeting and a notice requirement. You just, the board meets, they send a notice, that's it. You can also suspend the right for a reasonable time, the right of an owner to use the common elements through that suspension process that I just mentioned. That includes for failure to comply with the governing documents, but that one can't be imposed unless the owner has an opportunity to appear, and I believe it's a 30-day notice in that instance. Okay, so we're going to go through. I mentioned the fines. I don't really like them. The fining committee really serves as kind of judge, jury, and executioner. They have the unfettered right to levy the fine and say yes or no, whether or not the owner actually shows up. They're basically stepping on the judge's toes because that's what a judge does. The judge holds evidentiary hearings, just like the fining committee, and decides whether the fine was proper. The other thing, and perhaps the most important, fines can kill the board's credibility because they're almost never pursued in court. You would basically be filing a small claims lawsuit. I have seen one community in 14 years of practice that actually filed a small claims lawsuit to pursue fines without something else being added on. So the likelihood that you're going to go through this entire process, tell someone, hey, you know, we're not going to deal with this in a covenant enforcement context. We're not going to send you to arbitration or mediation. We're not going to file a lawsuit. We're just going to fine you. And then if you ever go to sell your property within the next 5 years or so, or if you ever go to get a mortgage within the next 5 years or so, we'll just throw it on the Estable certificate. And by the way, the first thing that boards are usually willing to waive when it comes to those Estable certificates and requests for a reduction of the balance is the fines. Okay, so you want to be consistent. You want to show everyone in your community, hey, you violate, we're going to take it seriously and we're coming after you. Don't mess around. We want this community to be the best it can be. You don't want it to be, well, the board does all these things, but they really have no teeth. They don't do anything. Okay, so what I would suggest rather than fining, have a written enforcement policy that says exactly how the community is going to react to violations, whether it's 1, 2, 3 notices from management or from the board, and then it gets sent over to council to deal with either via I call it a nastygram, which is basically a letter saying, hey, the board told us that you're in violation and they told you 3 times and you ignored it. What's going on here? You got 2 weeks to fix it, or we're going to go ahead and send you a statutory notice and then file a lawsuit, etc. But I do recommend strongly having that type of written policy in effect so that it's clear to all your members. Here's what we're going to do if you mess around. Okay, we discussed this, 90 days delinquent, you can suspend via board action only. Another avenue that's not mentioned here is a demand for rental payments if you know that the property is being rented. So that is, you can do that in addition or separately from what we're talking about here. And it's basically a letter, it's a statutory form, and it says, hey, tenant, your owner is past due and some monetary obligation to the association. Please send us your rent payments until you hear from us otherwise. And, sometimes that's effective. It usually works in areas like perhaps Kissimmee, Miami, where rentals are in high demand. It doesn't tend to work where there's not a big demand for rentals, because really your remedy, if the person doesn't pay that, is to kick them out of the house and then bring someone else in. So what we're saying as a legislature is, well, you can evict this person and take away the one avenue you might have had to actually get paid. It doesn't make sense to me, which is why, frankly, I've never recommended that a client of mine go through that eviction process unless you're going to get another person in very quickly that is then going to get that same rent demand. And if they don't pay, you'll evict them too. But keep in mind, the cost of that eviction, which could be a couple $1,000s, is on the association. And there's nothing that specifies that you can tack that on to the unpaid debt owed by the actual owner. So just be careful with all that. All right. We talked about this. The suspensions that we're talking about here apply to the entire unit, not just the owners. So if the ute's rights are suspended and they're renting, they have guests, they have family staying with them, none of those people are allowed to use the common areas that we're talking about. The suspension doesn't apply to limited common elements. We discussed that. The other thing is, you can suspend these use rights in the pool, the gym, whatever. The likelihood that someone's just going to let them in anyway, I have not experienced a ton of, unless you have a lifeguard on duty or security at the gate, something of that nature. The likelihood is someone's going to let them in anyway. But if you're able to enforce that, I strongly recommend using this suspension, because a lot of times it is the way to get people to kind of come into compliance. You can also suspend the right to vote, which is an important one. This is through board action. It's again, 90 days delinquent. For that suspension to take effect, you need to give written notice to anyone that is being suspended. The delinquency needs to be more than $1,000, and you need to provide proof of that obligation to the owner 30 days before the suspension takes effect. Okay. Now, there is recent case law from 2020 that says that the authority to do that suspension needs to be in the declaration, or the declaration needs to contain Kaufman language, like we said earlier, incorporating new procedures and new substantive rights in order to suspend these rights. You're really going to just want to confer with your own attorney and find out, the association's counsel, and find out whether this is something you can do rather than just take a guess. Okay. Because keep in mind, taking away voting rights is a huge right. It's the main right other than the right to use this person's property. So you want to make sure that you're doing everything you can to, if you're going to restrict that right, to make sure you do it correctly. Practically speaking, it's crucial also to ensure that your financial records are accurate, because again, you need to provide proof that this person's actually delinquent and by at least $1,000. And if you don't have the records to support that, then you won't be able to levy that suspension. The other thing to keep in mind is that voting right that is suspended isn't counted towards a quorum and isn't counted towards a vote. So you basically lose that vote for purposes of quorum. So that's something to keep in mind. If you have 95 possible votes because you used to have 100 members of your community and 5 of them have been suspended and no longer have the right to vote, you now only have 95 units to meet that quorum requirement. Okay. So just bear that in mind when you're levying these suspensions. Do it in a way that you're still going to be able to meet your quorum requirements if you've got things coming up. Yes, you may want to suspend these people from being able to vote, but you also want to make sure that that vote and that entire meeting are not wasted. Okay, member meetings. The annual meeting, the bylaws say when and where you're supposed to hold them and how to call them. And if they're silent, you just need to call it within 45 miles of the condominium. Special member meetings are basically all other meetings of the association. They're held whenever the board calls one, or the members can, by written request of at least 10% or whatever percentage is in your governing documents, the members can actually call this type of meeting for a specific purpose. Could be an amendment, a recall, which we'll talk about later, to waive or only partially fund reserves, which we'll also talk about. And then there are a whole slew of other reasons that you might want to call this type of meeting. The members are entitled to at least 14 days notice of member meetings via mail, hand delivery, or electronic delivery. Electronic means either email, fax, or something similar. Make sure that you have an affidavit by the person that's providing the notice saved in the association records. This is not only required by statute, but almost more importantly, it's your documentation to show that you actually gave these people notice, so that if they don't show up at the meeting, they can't say, well, I had no idea you guys were going to meet and vote on this. Even the annual meeting notice needs to include an agenda. Special meeting notices will need to supply clarity as to what's going to be discussed during the meeting. And then there are other issues like special assessments that you need to give specific notice and specific statutory types of notice and language to use. So keep all that in mind. Electronic notice is only allowed if the member consents to it. In other words, you can't just email everyone and presume that that's good enough notice. And it also can't be used for recalls or votes regarding retrofitting condominiums with fire sprinkler systems. That was a huge issue about 4 or 5 years ago. So keep in mind, if you want to have electronic notice, that's great. It'll make things easier for everyone. It'll make things easier for the board or your manager, but you need to have everyone actually approve. And when I say everyone, I mean each individual member. So you need to keep records of who approved and who didn't. That can be as simple as a spreadsheet of all of your members with a yes or no. But just keep in mind, you need to keep those records. An owner who designates that email address and says, yeah, I'm going to get notices this way, they're responsible for ensuring they receive the emails. The association only needs to make sure that it's properly sent. So if you get a bounce back, technically that's not on the association. And when I say a bounce back, I mean an email that says this was not delivered. Make sure that you got it to the address that the owner provided you. If it's done in handwriting, make sure that you read the handwriting correctly. But other than that, you've done what you need to do if you sent that out. Okay. Now we talk about handicap access. Membership meetings may need to be held at a location that's accessible to physically handicapped persons if requested, and that person has the right to attend the meeting. That means if you're holding your meetings via Zoom and someone is blind, deaf, or otherwise impaired in a way that means they can't attend a Zoom meeting, you probably still need to, and when I say impaired, I don't mean that in the Americans with Disabilities Act context, but even if they just don't have internet access, you need to provide a physical location for that meeting, for a records inspection, for whatever you're doing. Okay, so these are just things to keep in mind. Quorum is basically a majority of the members, unless your governing documents say otherwise. And I say basically, but it is a majority of your members, unless your documents say otherwise. Member decisions require a majority of votes during a meeting when a quorum is present, unless your bylaws say otherwise. Now, this is a big one. Members can attend and speak at meetings regarding all agenda items or items that are open for discussion. What that means is that the association can and should, I say should, almost must, adopt a policy restricting the frequency, duration, and time, at least up to 3 minutes by statute, for member statements. Okay. And I hear a lot of communities that say, oh, we don't have any problems, so we don't need that type of policy in place. We all get along during our meetings. That's great. Okay. I promise you, though, that at some point you're going to have that one person that creates an issue, and all of a sudden you're going to say, man, I really wish I had created this policy and reached out to our attorneys to create it a couple of years ago when Alan suggested it to me during this condo board certification class. Because now, it's not too late to do it, but this person is interrupting all of our member meetings, all of our board meetings, and we just can't do business that way. Okay. Members can also record your meetings. So keep in mind, that may not be something you want, but the purpose of having an openness requirement in board meetings and member meetings is so that the people that are entitled to knowledge of what's going on are able to access the knowledge of what's going on. It's not just the meeting minutes, it's they overhear the discussion. They can participate in the discussion to some extent. And again, you can have a policy that limits that, etc. If you're having a closed meeting with counsel to discuss potential or ongoing litigation, or you're having a meeting to discuss employees' salaries, et cetera, are still open to members, but the employees themselves, hiring decisions and things of that nature, disciplinary things, those can be closed to the members along with attorney-client privileged meetings, okay? You still need to provide the same notice, but you can close the meeting so that not everyone is able to attend. Okay, you can vote by proxy in many, but not all items. A general proxy basically says whoever holds this thing can vote however they want on anything that's going to be discussed at the meeting. Okay, but at a specific meeting, it's not a general proxy for all items forever. It's for this particular meeting. A limited proxy says this person is allowed to cast a vote on my behalf in a certain way at this particular meeting. Okay, in condos, limited proxies must be used for votes taken to waive or reduce reserves, votes taken to waive financial reporting requirements, and to amend the declaration or amend the other governing documents, and any other matter for which the Condo Act requires or permits a vote of the unit owners. Okay, so in other words, you're not just sitting there and casting a ballot. This is your ballot. Okay, you're using a limited proxy. General and limited can be used to establish quorum. No proxy can be used for other business. Okay, so I talked about the things that you must use it for and can use it for. You can't use it for other items. Okay, you can't just use it for everything. Any proxy is only valid for that specific meeting. It won't be valid for longer than 90 days after the date of the meeting that it was initially given for. In other words, if that meeting can't take place because you didn't get a quorum, the next iteration of that meeting, if you have 3 in a row and it's all within those 90 days, you're fine. But if you hit day 91 after that first scheduled meeting was supposed to occur, it's no good anymore. You can't use that proxy. You need a new form. Okay, it's revocable at any time at the pleasure of the member executing it. In other words, if you give someone your proxy and you later say, you know what, I'm going to go to that meeting myself, you can revoke your proxy. Okay, written consent in lieu of a meeting is basically something under the Corporate Act, not under the Condo Act, and it basically authorizes the board at a properly noticed board meeting by motion or resolution to allow the membership meeting to be held virtually with members participating by means of remote communication. The same procedures are recommended as you would have as at a board meeting. Now, this written consent in lieu of a meeting is a document that can be used unless it's prohibited in the articles. It's good for 90 days from the date the first executed written consent is received. And that's basically a way of gathering written votes. People tell me, you know, I had someone within the last week in an HOA argue that you can't, what's the term? Harvest ballots. Well, in this case, you actually can. So, you know, I had the argument, this isn't, I think it's Maricopa County. Well, I don't really care where we are. We're in Florida and the law allows this. Okay, we'll talk about elections very briefly. Okay, to one thing to keep in mind, to avoid disputes over the validity of the election result, you need to formally close the balloting at some point. So you're actually able to leave and have an election result by the end of the night. You're basically saying, okay, we're no longer taking ballots. We're going to start counting them now. Okay, there's no quorum requirement, but at least 20% of the eligible voters must cast a ballot in order to have a valid election. Okay. If you don't have an election, you just hold over for another term. That's pretty much it. The process is regulated by Chapter 718 and the Florida Administrative Code. Basically, you have inner and outer envelopes. Inside the inner envelopes is your ballot. That set of documents is delivered to the board. Okay. That's how you vote. The board then takes the outer envelopes, takes the inner out of the outer, checks to see whether or not there are duplicate votes for that same unit, and uses those inner envelopes to count the ballots and count how people voted. Okay, so just keep in mind, this is fairly procedural. I think elections are important, so I'm going to go through what the notices required are, but that's the basic procedure. Okay, so at least 60 days before the election, the association mails a notice, and that's either mailed, delivered by hand, or electronically transmitted, a first notice of the date of the election. That basically says, here's when we're going to hold the election, just get ready. Okay, any unit owner that wants to be a candidate, and this is the reason that 60-day notice is required, needs to give written notice to the association not less than 40 days before the election is scheduled to occur. If the candidate requests it, the association needs to include an information sheet, which needs to be furnished by the candidate not less than 35 days before the election. In other words, no more than 5 days after they are basically required to submit their desire to be a candidate. And that document is included as is. No changes can be made by the association. It just goes into the mailing for the final documentation, which is at least 14 days before the annual meeting. So that's the written notice and agenda, the second notice of the election, the information sheets for each candidate, and that's what goes out for at least 14 days before the election. You also need to post notice of the election on the association's website if you're required to have one. We'll get into websites later, but it's basically if you have more than 150 units in your condo. And now, if you look at the top here, what we're looking at are, here are the deadlines. So it's 60-day notice, 40 days for candidacy, 35 days for the information sheet, and 14 days for the actual final notice of the election meeting. Okay, elections are decided by whoever gets the most votes. If there's a vacancy that's caused by the expiration of a term, that needs to be either filled by an election, or it could instead be filled by the board appointing someone. A resignation is generally always going to be filled by appointment or election, and that, honestly, don't have an election if you don't have to. You just heard the significant effort that it takes to get through that election process. Why would you want to do that more times than you need to? All the official records, the ballots, sign-in sheets, etc., are things that you need to hold on to for at least a year. Something that I've actually heard, and we discussed this a minute ago, it's just something I hear fairly frequently that's dead wrong. Well, they didn't have an election, so everything they've done in the last 10 years is invalid. Well, no, the board carried over because no one wanted to be on the board except for the people that already are. If you don't get enough nominations to hold an election, you don't need to hold one. There's no point in wasting your time. So just keep in mind, unless there are more candidates than vacancies, in other words, you've got a board of 5 members, 4 people submitted their names in the hat, why would you possibly need to hold an election meeting? There's not enough people to even go around with the 5 positions you've got. You're already going to have to find another person after the election. Okay, so you don't have to hold it. And then any challenge to the election process must be commenced within 60 days after the results are announced, not necessarily the date of the election, but after the results are announced. Okay. A candidate means someone who's eligible to be on the board, which is pretty much anyone except people that didn't submit their candidacy forms, people that were convicted of a felony or something that would be a felony if it occurred in Florida and didn't have their civil rights restored. In other words, weren't released from prison at least 5 years ago, and people that are delinquent at least 90 days in payment of any monetary obligation to the association. Anyone other than those 3 people can be a director that is a member. Now, your governing documents, your bylaws generally may say you don't have to be a member to be a candidate or to be a director or an officer. If that's the case, fine. But that's only the case if your governing documents are very specific and say that. So let's see. We talked about all that. So we talked about someone convicted of a felony. Another thing that someone can't be a candidate is someone who's been removed by the division or suspended can't be a candidate. If they owe an assessment in a residential condo of more than 10 units or in a residential condo that doesn't include timeshares or timeshare interests, co-owners cannot serve as members of the board as directors at the same time unless they own more than 1 unit or no one else wants to do it. Okay, so in other words, Jim and Jane are married. They live in unit 5 of the condo. There are 20 units in the condo. Well, generally speaking, they can both be candidates. So from a practical perspective, they're both candidates, but they can't both serve if there are 6 people that wanted to be on the board in that 5-member board community. Okay. In other words, there were more candidates than you would need to fully seat the board. Person serving as a board member who becomes more than 90 days delinquent in any monetary obligation is deemed to have abandoned the seat, creating a vacancy. Again, this is a statutory automatic event. It is not something that the board votes on. It is not something the board can say, no, we're not going to do it. It is automatic. Now, I've certainly seen directors who said, we don't want this person off the board. We'll give them some time. My strong suggestion in that instance might make them sign a document that says when they're going to pay it back, and therefore they are under your purview, not delinquent anymore, because they agreed to pay it on this date and that date didn't come yet. Okay. But bottom line, once they become more than 90 days delinquent, they're off. You don't get to question it. Even if they owed $150,000 for the last 90 days and they pay $149,999, still not good enough. Okay, they have to pay the whole thing. All right. The board is 5 unless the governing documents say otherwise. So there's 5 directors. Condos with 5 or fewer units, it's only 3. That makes sense, because why would you want everyone needing to be on the board and also comprising your full membership, right? The term expires basically at the annual meeting. You can stand for re-election unless it's a timeshare or non-residential condo. If the staggered term hasn't expired, in other words, you do 2 or 3 year terms for each of your directors and they expire at different times, and this director's hasn't expired, or if all the directors' terms would otherwise expire and there aren't any candidates. In other words, you roll over. There is an 8-year term limit that is now in place. So if you've been a director for 8 years, unless you've got no one that wants to be on the board, you cannot serve for that 9th year. And then again, we talked about co-owners. Okay, I'm not going to go through the specific process of verifying the outer envelopes, but just keep in mind, this is basically what you need to do is to disregard the people that have voted more than once and make sure that everyone that is voting is entitled to vote. Okay, officers. Now, we didn't talk about the difference between officers, directors, and members. Okay, your members are the people that own a unit in your condo, period. It's that simple, unless your declaration somehow says otherwise, which I've never seen one that does. Okay, your directors, that's your board. Those are the people that make motions for the association, vote on motions for the association, and second them before the vote. Okay, that's literally a director's entire job. You vote on board matters at board meetings, or you have that written certificate that I mentioned earlier on behalf of the entire board unanimously. Okay. The officers are the people with specific positions, the president, the VP, the treasurer. They are the people that are the ones with specific obligations under the declaration. Many of those obligations may be passed to your manager via the management contract if you are a managed community. Okay, so just keep in mind, it is entirely feasible that you are responsible for things under your bylaws that because you've delegated that responsibility to management, you no longer have to do. For example, generally speaking, the secretary is the one that takes meeting minutes, stores all of the governing or all of the association official records. Well, if your manager's agreement says that they need to do that, you don't have to do it anymore. Okay, so keep in mind, these are just things to be aware of. Electronic voting is fairly complicated, and you should reach out to your manager or your voting vendor. And if you don't have one, reach out to your manager or our firm. And I don't know of one in particular, but we can certainly put you in touch. But it's not something that it's something that's becoming more prevalent that I haven't personally dealt with very much. So this is one of those things we'll skip through a little bit. We went through who does what. Your directors and officers may not be your members as well. And the board, frankly, has most of the power in your community. The directors and officers, this is huge. So please listen up if you're on this call as a director or officer or on this webinar. Directors and officers owe a fiduciary duty to the members as a whole and to the association. What this means is you actually have the highest duty imposed by law to do what you reasonably believe to be in the association's best interest. Okay. The business judgment rule is going to help you out here. It's okay to be wrong as long as you have a reasonable belief. Okay, if your attorney told you absolutely don't do that and you do it anyway, sorry, but that's not a reasonable belief. Okay, unless you also have a law degree and are practicing in this area and have reason to believe that your lawyer is wrong. And in that case, get a second opinion so that you have some documentation showing that, you know, your lawyer is wrong and you're allowed to do whatever it is you want to do anyway. The board must exercise best efforts, purchase insurance, rely on advice and guidance of experts, like I just mentioned, etc. The directors can't be compensated unless it's authorized in the bylaws, unless it's for work performed through your trade or your company with full disclosure and abstaining from decisions regarding that project. In other words, there's a conflict, that's okay, but you need to disclose it. Okay, fiduciary, this is a legal term. It basically says it's the highest duty. The good news, it's judged by the lowest standard. You'll excuse me, but it's the dumbest person in the room standard. Okay, in reality, what we're looking at is if there's any reasonable basis to believe that what you are doing would be in the best interest of the association, this business judgment rule is generally going to protect you. The other thing that's going to protect you is your second most important bill that a community association director can ensure is paid. That's your directors and officers liability insurance policy. And frankly, if I was in a condo and I was on the board, I would stop serving until that's paid, because that's what's going to protect the individual directors and officers if they get personally sued. Now, I mentioned that's the second most important bill. If you're one of our clients, the most important is, of course, ours, because you're getting guidance. It's very important. That's why we're your counsel. Okay. All jokes aside, that directors and officers liability insurance is truly extremely important. Make sure you have it before you make any action on behalf of the association. Okay, the corporate powers of a corporation not for profit are exercised by the board unless otherwise provided. In other words, unless your governing documents or Florida statutes say the members get to vote on something, they don't. You deal with that at a board meeting. No board member, not even the president, should make unilateral decisions unless powers delegated for a specific purpose or it's an emergency. The board's generally going to be responsible for maintaining the association property. These are health, safety, and welfare powers. So just keep all of this in mind. This is the board's responsibility. Now, when does a board meeting occur? When is it a board meeting? I hear a lot of people saying, well, you guys as an association and a board are subject to sunshine law. Well, no, that's a corporate, that's a municipal governmental law. It's a completely different statute that has no application to us, but it's still similar to what we're subject to. So we don't need to turn over everything we ever do, but we do need to allow members to attend meetings. We do need to keep official records, which is pretty much everything regarding the operation of the business, of the community, etc. A meeting is anytime the association board meets, a quorum of the board, to conduct association business, whether that was the original intent or not. Once you start conducting association business and making decisions for the association, that becomes a board meeting, okay? I usually give some examples. One is if you're out for a happy hour and 3 of your 5 directors, that's a quorum, are meeting at happy hour, and you start discussing the association and deciding, you know what, we're going to have a party and we're going to have the association pay for it and all the members are going to be invited. Well, technically, you just had an illegal board meeting. Okay, so just be careful. You know, you can make decisions and ratify them later, which is what this slide says right here. Board can take action outside of a properly noticed board meeting and ratify it later. You can also have a written consent, which we discussed earlier. If a decision is unanimous, everyone just signs a document that gets put in the association's official records. You didn't need a board meeting because everyone just was able to easily decide. And then email, you can email to communicate. You cannot use email to vote. Now, the other thing to keep in mind, have a separate email address that is not directly connected to your personal email. Have like a board@whatever.com or you know, whatever you're looking at. It's just important to keep that stuff separate because technically it becomes an association record, whatever's in your email that is pertaining to the association, which means that people could be fumbling through your email account if you don't split it up. All right, now I'm going to speed up a little bit. You can't accept free things of value or ask for free things of value. if there's no consideration provided, meaning you didn't pay for it, that benefit you from someone that's providing or proposing to provide goods or services to the association. That can be a civil penalty and possibly a criminal penalty if you accept it. There's no prohibition against accepting services or items received in connection with trade fairs or education programs. In other words, we just recently had the Orlando, the Tampa, or I'm sorry, Bradenton, and a couple other condo expos. Those are the types of trade fairs we're talking about, and education programs is events like today. You're guilty until proven innocent if someone charges you with embezzlement or theft, at least from the community association context. Basically, you're out until those charges are dropped against you or you are found to have not violated. So you are off the board the second that you are basically accused or charged by police, not by someone within the community, but charged by police or charged by, the district attorney, whoever it may be, state attorney. That vacancy is filled by the board until the end of the suspension or the term, whichever occurs first. Okay, and that's, again, if that not guilty verdict comes down or the charges are dropped, the director shall be reinstated, meaning I don't care that you don't believe what the police decided or the state's attorney decided. If that person is found not guilty or the charges are dropped, they are reinstated, period, whether you like it or not. Board meetings, generally, you need to give 48 hours notice, posted on the condo property. That's for board meetings, not member meetings. And then if you're talking about a non-emergency special assessment or an amendment to unit or parcel use, in other words, your rules and regulations, et cetera, you need to give 14 days notice instead of the 48 hours posted notice. You do need an agenda for every board meeting, just like member meetings. Notice of where you're talking about regular or special assessments. Need to specifically state that those assessments are going to be considered and the estimate cost and description or for those assessments themselves. If 20% of the voting interest petition the board to address a specific item at a special board meeting, the board within 60 days after receiving that position must have a meeting and must include that specific agenda item during that meeting. Okay, members are entitled to participate. This is yet another one that I would strongly recommend. You have a written policy of rules governing frequency, duration, and manner of member statements. You could even have one policy, like I said earlier, that addresses the member meetings and board meetings. So everyone is treated equally across the board. Everyone knows what these regulations are. Everyone knows what is required in order to be authorized, not entitled, authorized to speak during these meetings. Okay. Now, I said members are entitled to participate. Remember, there are exceptions where you can close a meeting when you're talking about potential or ongoing litigation or personnel matters. Quorum is generally a majority of the board. When that majority meets, you can do so by phone. That's counted. If you can meet by Zoom or any other electronic means, that's all counted towards attending the meeting and reaching a quorum. You may need a speaker so that everyone can hear. A lot of times I'll attend meetings via speakerphone. There's nothing wrong with that. Someone calls my cell or calls the office, they click the speaker button and everyone can suddenly hear me and I've attended. The board members, the directors, everyone can do the same thing. Okay. What do a golem and a condo board workshop have in common? They're both mythical. Okay. A workshop doesn't exist. You can't have a closed workshop just to get around noticing board or committee meetings. Okay. Committee meetings where you're talking about taking final action on behalf of the board or making recommendation regarding a budget are always subject to meeting notice requirements and can't be exempted. Budget recommendations and non-final action, you don't necessarily need to provide notice of that committee meeting, and you can close it to the members if the bylaws exempt a meeting from that notice requirement. Okay, conflicts aren't always bad. So keep in mind, yeah, they need to be disclosed 100%. A conflict is basically that the director has an interest in the corporation, the entity, whatever, that is proposing to do business with the association. It could be a landscape vendor, could be a painter, whatever it may be. There's nothing wrong with that specific conflict. Okay, the only time it becomes a problem is when it's not disclosed. Okay, if it's disclosed and the director who is supposed to be getting involved does not attend the portion of the meeting where it's being discussed and voted on, and doesn't argue, doesn't try and influence the decision, you're good. The conflicts can actually be good because sometimes it means you get a better price. If you're working on behalf of your own community, you might give a better price than anyone else is willing to provide. And so again, these conflicts are not bad, they just need to be disclosed. Okay, the director can present the contract, and you need a 2/3 vote of the other directors rather than a majority of quorum in order for that that contract or transaction to be approved. All right, this makes sense. You don't want intimidation, influence, etc. It's just not a good idea to have that overexertion of influence. All right, so and we talk about what a relative is. If your relative under this definition is also owns a company that wants to do business, same thing. You just need to disclose it and step away for purposes of the vote. Okay. Okay. If you don't properly disclose this, in other words, you didn't say, oh, hey, by the way, this is my brother's company that we're proposing to do business with, then that conflicted contract is voidable. It terminates on the filing of a written notice terminating the contract with the board, which contains consent of at least 20% of the voting interest of the association. In other words, this is how you get out of that contract after you find out there's a conflict that wasn't disclosed. And there are also criminal penalties for forgery of ballot envelopes or voting certificates, theft or embezzlement, of course, and then destruction or refusal to allow inspection or copying of an official record that is accessible to unit owners within the time provided by law. Here's the important part: in furtherance of a crime. Okay, that's basically tampering with evidence. So these are all things that, as a director, technically they are criminal items. You can be literally charged with a crime for doing any of those things. If criminal charges are pending, that person's off the board. If there's no finding of guilt, they get reinstated. It's what we discussed earlier, just not about embezzlement. There are 6 ways to get off the board. You can resign through a recall. You can be delinquent in payment of any monetary obligation for 90 days or more. You can have criminal charges involving theft or embezzlement of association funds or property, or you can willfully and knowingly violate the Condominium Act. And in that case, it's only if the division removes the officer or director. And then finally, failure to satisfy the certification requirement you're here for, that's a suspension. The other way is you die. But in that case, you can't really serve on a board. Budgets, reserves, we'll go through this extremely briefly, but essentially you'll want, if you have an accountant, if you have a property manager, you're going to want them to do most of this work for you. A budget, by the way, is the board's best guess of what you're going to need to properly maintain and operate the community over the course of the next year. It's not I need to follow this step by step. It's here's what we think is going to happen. If that's not what happens, what your obligation as a board is to properly operate and maintain the community. If that costs $100,000-$200,000 more than you anticipated, that is your fiduciary responsibility to the members and to the corporation to make sure that that $100,000-$200,000 is spent. If you're backing into the budget, meaning you're only spending what's in there, you're probably not properly operating and maintaining the community. Okay. If you need in your budget another $1 billion, you literally need to add that $1 billion, and then the members get to come back and say, we don't want to pay that, we can't afford it, we won't do it. So we're going to present a separate budget that the members are allowed to present at another budget meeting, and that, if it is voted in, is your budget for that year. But you as a board, you as officers and directors have complied with your fiduciary responsibility to be transparent, open, and honest about what the budget should include. The owners have a right to know how much the budget should be. Whether or not they approve that budget is up to them. Okay. If you're not doing this and you're cutting back, you're just not servicing your community the way that you are legally obligated to do. And the association, the members are going to eventually find out, and you'll have even bigger problems. Think about, I hate to use it as an example, but think about what happened in Surfside, Florida. Okay, an entire building collapsed. Now that was a reserve issue more than anything else, but it was exactly this. The directors didn't want to spend the money. They finally decided, you know what, we've got an engineering report that says we've got some problems. Let's go ahead and propose to spend the money, and then the members shut it down. Well, the members shut it down, and that's not something the board can control, but it's your responsibility to make sure that you're actually doing what is right for your community, not what's right for you as a director to try and get reelected next year. Okay, these are things that the budget needs to include. The budget is adopted by the board at a properly noticed board meeting that's open to all unit owners. That the board needs to provide a copy of the annual budget 14 days in advance of the budget meeting. And then you guys get to vote on it as a board. And again, if the members want to change the budget, that at that meeting, they can say, we have a separate proposed budget. We want to substitute that one in. Let's see, if the board changes the budget during the noticed board meeting, you don't need to resend or renotice the board meeting. You just adopt the different budget. That separate budget also additionally, not separately, not to replace the original, but that adopted budget goes into your official records. Okay. It needs to take place, this adoption, at least 14 days prior to the start of the fiscal year. That could be January 1st. That could be somewhere in October. It could be in the middle of the year. It just depends on your bylaws. If you don't adopt the annual budget a second time, it's deemed a minor violation, and the prior year's budget continues in effect until the new budget is adopted. When I say a minor violation, I mean the DBPR is going to come after you if they get wind of it. Okay, and they will. We talk about reserve items. What we're talking about here is things that are going to last a long time, that you need to save up money for, so that when those items fail, those assets fail, you've got the money to fix them or replace them. Okay. The budget must include reserve accounts for capital expenditures and deferred maintenance. And I defined those terms a minute ago, but it's basically reserve items, including roof replacement, building painting, pavement resurfacing, and anything else with a deferred maintenance expense or replacement cost of over 10 grand. Now, I'm not going to go into detail because we're running short on time about Senate Bill 4D and the law that was passed as a result of that Surfside horrendous event. But there are additional items that have now been added to this list that you see on your screen. And it's the roof, the load-bearing walls or other primary structural members, whatever that means, your floors, foundation, fireproofing and fire protection systems, plumbing, electric systems, waterproofing and exterior painting, windows, and then again, anything that would be over $10,000. There's a lot of requirements that have now come out that you need to comply with. Get with your attorney. They are not required to be complied with until the end of 2024, but they are reserve studies that need to be performed in advance of that date. So get started looking into it now, figuring out what it's going to cost and how you're going to pay for it, because it will drastically increase potentially what your reserves need to be. And by the way, the DBPR has said that you will not be allowed to waive those reserves, even if your members want to. So this is going to be a drastic increase in a lot of communities' assessments. It's just something to keep in mind for now, but potentially to look into, so that 2 years from now, when this takes formal effect and you are going to have to comply, you're already ready for it. Computing the reserves, there are two different formulas you can use. One is called a pooling formula, and that is basically you have the funds available for each item as it dies out or needs to be repaired or replaced. The other one's called a straight line formula. That's the one that I frankly prefer because it's very simple. Okay, to determine what you're placing in the reserve, you need to figure out what it's going to cost to repair or replace this asset once it's no longer useful in its current form, how long that's going to take, which we call the estimated useful life of that asset, and what method you're using to calculate each year. Okay, the straight line method, I'll be just real quick. If it's going to cost you $100,000 to re-roof your clubhouse and the roof has a life expectancy of 10 years, you divide the 100,000 by 10 years and you need 10 grand per year throughout those 10 years that goes into your reserve. That's the line item that you're saving for that roof. Under a straight line method, each individual item gets its own account, its own category, and you save for it separately and can't spend the money on anything else during those 10 years. You also need to account for the increase in cost or the decrease in cost when inflation happens. That's one basis you can use is inflation. You just increase every year or every 3 years. The alternative is what I mentioned earlier. It's called a reserve study. You basically have someone come out, take a look at this item, figure out what it is really going to cost to replace it in 10 years. And let's say you do that in year 4 and you find you have 6 years left to save, but it's going to cost an extra $20,000. You just add what you're saving, just divide that 20,000 by 6 and add it to what you're saving each of those 6 years. Okay, so that's straight line pooling. Again, it's basically make sure you have enough by the time that you are using any of that money to do what you need to do. It basically is a way to reserve the amount of the reduce the amount of the reserve budget and the assessments that you're charging. You accommodate for the fact that funds mostly sit around in a straight line formula and they're technically not necessary every year. I like straight line better because it's easier to create the budget. It's easier to account if you're just saving the same amount every year, unless you find that that amount is not enough anymore. Okay, waiving or reducing. Keep in mind, you might not be able to do either one of these under the DBPR's new interpretation of these laws that changed this year. But bottom line, if you're able to do it, the board adopts the budget with the reserves fully funded, unless the board, the members by majority of a quorum say otherwise. Pardon me. Again, you can only use the reserves for what is actually being reserved for. Can't use it for any other purpose unless a majority of the members vote to do otherwise, to use the funds for some other purpose. Limited proxy disclosures. This needs to go on the limited proxy when you're voting to waive or reduce reserves. It's statutory and it needs to be in capitalized bold letters in a font size larger than anything else on the face of that proxy ballot. The members are entitled to copies of the association's financial reports, which is a separate concept, okay? Within 21 days after the final financial report is completed by the association or received from the third party being an accountant or someone else that's creating your financials for you. But not later than 120 days after the end of the fiscal year, the association needs to mail or hand deliver everyone a copy of the most recent financial report or notice that a copy is available. If they don't do it, if the association doesn't, the unit owners can basically send something over to the DBPR 5 business days after submitting a written request to the association for a copy. It's just another basis for owners to complain that condos are doing something wrong is what it comes down to. If the division agrees with that, they'll send written notice to the association that it must do so, send that financial report to the owner within 5 business days and report to the division and send a copy. If the association doesn't comply and the association can't waive the financial reporting requirements for that fiscal year. In other words, you need to provide all the financials. In other words, instead of potentially a reduced rate. And we'll get into what that means in a minute. You need to provide an annual report to the DBPR containing all names of the financial institutions where you maintain an account. In other words, so that they can check into your funds, and a copy may be obtained from the department upon request of any association member. So here are the different rates of reporting that the association needs to go through. It's basically mo money, mo problems. The cash receipts and expenditures are all that's required if your revenues are less than 150,000. Revenues are basically what you brought in. And this cash receipts and expenditures is basically, here's what we brought in, here's what we spent. It now needs to include expense classifications like security costs, management charges, etc. So it can't just be dollars, but it needs a little bit more than that, but it doesn't require a CPA to get involved. It can literally be the association preparing it through the board. And it doesn't require any review. The treasurer is usually the one that's going to do this. Then you have actual financial statements, which the first level is compiled financial statements. That's if your association has 150,000 up to 300,000 in revenues for the year. You don't need a CPA for that one either. You produce your statements based on what's already in the association's records. You don't really review anything, and there's no assurance that this stuff is accurate. Okay, then you go up one level to a reviewed financial statement, revenues of 300,000 to 500,000. You do need a CPA for this one. There's a little bit of review of the association's records to make sure that these records are accurate. And as a result, there's limited assurance of accuracy. And then you finally have the bad mamma jamma, the audit. which is revenues of 500,000 or more. That's going to require a CPA because it's very in-depth. It's a full-on review of all association records, literally everything. And it's much more of an assurance of accuracy. The board can increase the requirement, but only the members can vote to reduce the requirement. And that makes sense. You want to have more control for the members. Okay, these are just some things to keep in mind. Also, annually required filings are required by the Division of Land Sales, Condos and Mobile Homes. We discussed some of them. The Division of Corporation, your annual report needs to go through, and then your income taxes in addition to your other financials. Okay, meeting minutes, keep them. Pretty straightforward, but they don't need to be verbatim records. It's not everything that was discussed. It's really just, here's what was voted on. Here is what the decision was, and here's how everyone voted. That's pretty much it. You can't abstain unless you have a conflict of interest. So I had this come up a couple weeks ago. My director said, I don't like what we're discussing today. I disagree with the way that the board is going. I'm just not going to vote. Unfortunately, that's not an option. Okay. You have to vote unless you actually have a legal reason that you can't vote if you are attending the meeting. If you are no longer on the board, you have 5 days to return everything after the new board and committee members are elected or appointed. If you don't, you may be sued. And that is a problem because people don't like being sued. The outgoing board and committee members who willfully and knowingly fail to return it are subject to penalties in addition to that lawsuit. And those penalties are imposed by the division. It is something that they will not hesitate to do. So keep that in mind. Association has an irrevocable, and I know that some of this may seem disjointed, but there's a lot to go through. So you can access a unit at any time during reasonable hours when necessary for maintenance, repair, or replacement of common elements or any portion of a unit that is maintained by the association or which might damage the common elements or another unit. Okay, this is basically emergency repairs. You might have, mold. There's also a procedure for finding a unit abandoned. It's not really a process. It's just, certain things. So keep in mind if someone is not in a unit for an extended time frame and you need to get in, you might want to reach out to your counsel to see if you can treat the unit as abandoned and enter it with notice, but with not quite as much. MARTA is generally something that doesn't apply to condos because the deeds refer back to the declaration, like I said earlier. So they reincorporate your covenants every single time the property is sold or there's a mortgage against the property. Generally speaking, the declaration is incorporated directly into the deed. So the Marketable Record Title Act, which would extinguish HOA and other covenants within 30 years, if they're not preserved, doesn't really apply. You need to allow process servers in. That's someone that's serving a lawsuit or serving a summons or whatever it may be. You can't tell them that they will not be allowed in unless they make an appointment or anything like that. Just let them in. You can create rules and regulations. Like I said earlier, the main points that I want to make, like I said earlier, you need to provide 14 days notice before you change or adopt those rules and regulations, and they can't conflict either expressly or by implication with language in the declaration, the articles, or the bylaws. Generally speaking, they also need to be authorized in the declaration or bylaws. So it needs to be something that you can reasonably say, well, here's the authority for this rule. It's not just we do whatever we want and we hope that a judge enforces it. And then a copy should be provided to each owner in advance of the effective date so that everyone knows about it, and then it goes in the official records of the association. If we're your counsel, the association's attorney and manager should also be provided copies of these rules and regulations once they're adopted. And frankly, I strongly recommend that if you're adopting them, you have your attorney take a look first to make sure that they are something that's going to be enforceable and you're not just wasting your time. Okay, maintenance. I discussed you really need to maintain the common areas. If you're changing the appearance of something during that maintenance, in other words, you're doing repairs and it's going to look different, you generally need that 75% vote unless the declaration says otherwise. There is Florida case law that says the board can do that type of alteration or improvement without approval and make those changes to the appearance when the alteration is reasonably necessary for maintenance, repair, replacement, or protection of a common element. So this was Tiffany Plaza was a rock revetment wall. What this means is essentially there's a case that says that if you are changing it for the purpose of protecting, a rock revetment wall was basically something that they installed to change the appearance of the seawall, but it was for the purpose of protecting the common elements behind that new installation. That was deemed okay without a member vote because it was something that was more protective. Material alterations, we kind of discussed this. I would read through this if you have time. Hurricane protection, the board needs to adopt hurricane protection specs by approval of a majority of the voting interests. The association can install its own hurricane shutters, impact glass, or other types of code compliant protection rather than the members doing so individually. A vote of the owners is not required if that action is the responsibility of the association already pursuant to the declaration. So this vote is only required if the members would otherwise be responsible for doing all these things. Okay. The emergency powers. This is one that we'll blitz through really quick, but the important thing to keep in mind is that these are generally powers that don't kick in and are not applicable unless you have something that is potentially going to damage the community, that is a declared state of emergency, either for your physical area, for example, Broward County, Orange County in particular, that county has declared a state of emergency, or statewide or nationwide. COVID is a recent example, and then the hurricanes that we had that were only passing through certain areas allegedly, you might have only had a state of emergency that would allow you to use these specific things, these emergency powers in those specific counties. So these are just things I would recommend reading through these, especially at least being cognizant that they exist and reading through them in detail the second that you hear there's another hurricane blowing through or something of that nature. Here's your board member emergency kit. If you've got an emergency coming up, make sure all this is available. Something that I'll personally add that isn't in our slides, a cell phone and several high capacity external chargers so that you can call in your vendors to make sure that you're able to reach out to people. Walkie-talkies are great. You've got your important vendor contact information. You don't want to have to run around in the middle of a storm going unit to unit or property to property asking someone to borrow their cell phone because yours is dead and it's been overused and you don't have a landline that's functional. Leasing and approval and amendments, you can only do it again if it's in your governing documents. The grounds for disapproval can include, but are not limited to, a unit owner being delinquent and paying an assessment at the time the approval sought. Okay, these new restrictions must be in the declaration and they only apply to unit owners who voted in favor of the new restrictions if they're adopted. In other words, if you have 100 units, 50 of them approved this regulation, 25 of the other ones bought in after, you've got only 75 of those units that are actually subject to this. The ones that voted no and bought in before the restriction took effect, it doesn't apply to their units until they sell, okay? Let's see, amendments, if the declaration is silent, amendments require a 2/3 member vote. And when we say 2/3, that's not 2/3 of whoever shows up at the meeting when a quorum is enacted. It is 2/3 of your entire membership. Okay. The proposal needs to contain the full text of the amended provision. There's a certain way of, wording it with striking and underlining so that it's clear what's being added and deleted and what's being changed. And amendments are effective when they are recorded, not when the vote takes place, not when the board signs the document that is a certificate of amendment, but when it's actually recorded. Now, if you don't think you can get the vote for an amendment that you're trying to do, start by amending the amendment provision to make the quorum requirement lower and make the voting requirement lower for these amendments. I know a lot of people don't like that idea because they don't want it to be easier to change their declaration, don't want it to be easier to change what is equivalent to their constitution. But if that's a problem you're having and you really need to make a change, that's one way that we've seen of, start with the easy one and then move forward with the more difficult substantive change to your governing documents. Okay, when is a manager required? Community association management, here's what it is, but it's required when it's done for remuneration, which is payment, and when the association has more than 50 units or an annual budget in excess of $100,000. If you don't have one of those two things, then you don't technically need a manager. My strong recommendation if you can justify the expense, and you can, a manager is well worth it if you hire the right property manager or the right property management firm if you go with a management company. Okay, these are people that are basically going to take on, like I said, almost all of the responsibilities of the officers. The directors at that point basically don't need to do anything other than vote. Okay, so it is well worthwhile. And as compared to the directors who may or may not have ever been involved with a corporation, which, by the way, your community association is a corporation that you're running. These managers are professionals that do this day in, day out. Okay. We're going to skip this. Debit cards. You're very limited in what you can use them for. An expense that isn't a lawful obligation of the association. In other words, if you mistakenly or intentionally use this for some other purpose that isn't board business, that's a crime and it's fraud. It's credit card fraud. Don't do it. Attorney hiring, you can't hire an attorney who represents the management company. Just to be clear, we do not represent any management companies. We represent almost exclusively community associations. So if you're on this, you can feel welcome to reach out to us. We work alongside a lot of management companies and we like them a lot, but we can't represent them for this reason. I'm going to skip through this, but just, you can read through because we are extremely short on time, about 15 minutes left. But this is about electrical vehicles. Basically, you need to allow these people to put charging stations in your community if they ask for it. Disputes, mediate. You're going to have two options if you're talking about a dispute between a unit owner and the association. You basically first notify them of the violation of your covenants, your rules and regulations, whatever it may be, in writing. And then you can either go to pre-suit mediation, which is my recommendation. You send an offer. If they respond, you go to mediation. If they don't, you go straight to court. Or you can go through an entire arbitration, which then needs to be enforced by a separate lawsuit. So nothing against the DBPR or the arbitrators, but there is case law that says an arbitrator can be completely arbitrary in how they rule. In other words, you may need to go back to court on an appeal rather than getting a judge to make a decision in the first place. So I always will recommend the mediation route. That is frankly why I decided to become a certified mediator. So the pre-suit mediation procedure, the owner has 20 days after you send your offer letter. If they don't respond, agreeing to at least one of the mediators of the 5 you suggested, or basically don't make the mediation payment or don't show up at mediation, you can move straight forward with your lawsuit. And the arbitration, these are things that the division has expressed jurisdiction over. I'm not going to go through all of them, but it's basically, this is all handled by the division and it's not something that you can take directly to court or to pre-suit mediation. So be aware of these. Your attorney should be aware of them as well if you're proceeding with this offer for pre-suit mediation or arbitration. Okay, expressly, the division doesn't have authority over these items, and I'm not going to go through them in depth, but non-binding arbitration becomes binding if you don't appeal within 30 days, or to enforce the decision, you basically need to go to circuit court. There are prevailing parties fees, but you're almost never going to get everything, because everything before filing the arbitration, except for one notice, you're almost always going to be told you're not entitled to any of that. And the arbitrators tend to drastically reduce all fees, whether they're actually reasonable or not. And it can be binding if the parties just agree that it's binding. There are new arbitrators that are in fairly regularly. That some of them are very good, some of them are arbitrary. Attorney's fees in general in litigation or in arbitration are only authorized by contract or statute. Okay, so keep in mind when you say, oh, well, I'm entitled to my attorney's fees, that's only if your contract or statute says so. Now, the declaration is going to say so, and the statute most of the time will say so, but not always. Okay, if someone refuses to participate in mediation, they're not entitled to any of their attorney's fees. So that's something to keep in mind. They lose the right to recover their attorney's fees, even if they win, if they don't respond to that offer for pre-suit mediation. Let's see. Condo websites, you need to have one if you have 150 units or more. That was effective January 1st, 2019. I'm not going to go in depth about what's needed, whether to have one or not. If it's not required is a tough call. If you're required to have it, you also need to post meeting minutes there. So, it needs to be very specific. You're going to want to work with a website vendor. Your management company might have that option, but keep in mind, You're going to want to make sure you maintain full control over the content of the website and the website itself, so that if you switch to another service provider, another management firm, you get to take that with you rather than having to start from scratch. That's the biggest thing, other than this one right here, which is make sure that all information is password protected. You can't get into any information except for the very basic, here's the address of the community and the person that you contact if you need information, without putting in a password. Okay, we'll skip through some of the rest of the website stuff. Let's see. You can also have an app for, and this is for condos or co-ops. If you are required to have a website, you can do it via an app as well, so that it's easier to access. Official records is literally, we're going to skip ahead to this last one. Let's see. I'm looking for the catch-all, but I didn't see it. So basically, the official records are literally every document that relates to the operation of the community, whether that's a napkin that has plans for a meeting that's going to take place or anything. There are certain timeframes you need to maintain those for. So just keep in mind that there are, it is important to know how long you need to keep everything. Some of your records you need to keep from the inception of the community. So I would just ask your counsel, hey, can we destroy these or get rid of them before you get rid of any condominium records? There are certain records that are not accessible by members: attorney-client privilege or work product relating to litigation or adversarial administrative proceedings, which means something that's with the DBPR, information obtained in connection with approval or leasing, medical records, and a whole host of other items that are not subject to disclosure. An owner can consent to disclosure of their own information. And if you do, then if they consent to it and you disclose that information, it's fine. Also, if you inadvertently disclose information that you weren't supposed to disclose, then it's kind of a no harm, no foul. Well, it wasn't intentional. I didn't realize that it was in the batch of 100,000 documents that this person asked to inspect. And by the way, you can have a records inspection policy as well that limits the time, frequency, of duration of those records inspections. Okay. Any record that's protected by attorney-client privilege, etc. Emails and letters from the association's attorney don't have to be disclosed. The board can waive that privilege if you want to. The privilege also ends by the time that the potential dispute ends. So that attorney-client privilege is not forever. The request, like I said, members of your community can ask to review the records. That inspection needs to be offered within 10 business days, within 45 miles of the community, or within the same county as the community. A renter also has the right to inspect and copy the bylaws and rules. Not everything else, though. Only the member has the right, or the member's designee has the right to review everything. They also have the right to make copies up to a certain limitation. They can use the copies, use a portable device, including their tablet, smartphone, portable scanner, or whatever can scan at no charge. The association can charge the actual cost for preparing and furnishing the documents and all of this other information if there is a cost. If there's no cost to you, you really don't charge for it. If it's copies, you can charge up to, I think, 25 cents per page for copies that are 25 copies or more. Again, you can adopt reasonable rules governing this. And again, I'm breezing through this because we have 9 minutes left and I'd like to get to at least one question. Your official records, if you don't provide it, you're basically offering these people a free $500 because you get $50 in automatic statutory damages for every business day beginning on the 11th working day after receipt of the written request. In other words, don't give them that gift, give them the documents. And by the way, providing an offer of here's where and when the inspection will take place. If they say no, that's on the owner. That's not on the association. You're not required to say, well, we'll come to your house and bring the documents. Doesn't matter. Okay. Faxes and emails, that's personal information that you don't need to disclose unless it's to fulfill notice requirements, etc. Okay, contracts and bids. These contracts need to be in writing. Okay, anything that's not to be fully performed within a year after the contract. In other words, it's a 3-year management contract that has to be in writing. It's a 2-year landscaping contract, needs to be in writing. Or for the purchase, lease, or renting of materials or equipment that's going to be used by the association, or contracts for providing of services. All that needs to be in writing. Okay, there are certain things the contract should specify, who's obligated to do what and when, and how much it's going to cost are all things that you want to make sure is in every contract. Now, if the aggregate cost of the contract exceeds 5% of the association's total annual budget, including reserves, you need to obtain competitive bids for the materials or whatever it may be. There are some contracts, usually professionals and employees, including attorneys, that are not subject to that requirement. You don't have to accept the lowest bid. Just like I said, it's okay to have conflicts because it might get you a good price. You got to go with whoever you think is the best option as a contractor or a service provider. You don't have to go with whoever offers the lowest bid. This talks about canceling contracts, bulk communication contracts, which is basically internet and cable. Okay, so we have assessments and foreclosures. I'm going to go through this real quick. Okay, you send your assessment notice. The owner has an obligation to pay it on a certain date. If you're going to change that method, the owner needs to actually agree in writing that they understand and accept the new method of delivery. What that means is if you've been sending payment coupons and you get a new vendor and it's a different payment coupon, or they're only accepting payments online, you may still need to accept payment via those coupons and a check. Okay, until each individual owner, just like the leasing requirements we talked about, until each owner accepts that new method. Okay, the procedure is you levy the assessment. If they don't pay it on time, you basically send a notice of late assessment that says you didn't pay everything. It's good for 30 days. It doesn't include any attorney's fees or costs, but it can include interest and late fees. Don't charge interest on that interest and late fees. Now, if that 30-day letter expires without payment, you can send a notice of intent to file a claim of lien. Okay, this is a notice of late assessment. Then you send your notice of intent to lien. It's good for 45 days. And it basically says that, okay, well, you didn't pay in the time provided by the notice of late assessment. If you don't pay within the 45 days provided in this letter, we'll file a lien against your property. Then you go ahead and file your lien. This talks about first mortgagee assessment liability. That's going to be a case-by-case analysis, so it's a good one to skip for now. But just keep in mind that you're going to need your attorney to determine if someone buys at a lender foreclosure sale, what is the new person that owns the property actually owe. So again, going back to that procedure, your notice of intent to file a claim of lien expires. There's no payment. You file your claim of lien and send a notice of intent to foreclose. If that 45-day notice expires without full payment, then you file your foreclosure action and go through the whole lawsuit. Okay. Acceleration of lender's foreclosure. You can set a trial date once an answer has been filed. You can set a motion for hearing if it's been filed to try and keep the case moving. Ask the court to set a foreclosure sale. And if the right conditions exist, you can request an order to show cause. Basically, that means that no one's filed anything against the foreclosure, and the judge should basically order everyone to let the judge know, hey, if there's a reason I shouldn't just go ahead and enter this judgment and set the foreclosure sale, please let me know. Directors and officers and managers or management firms cannot purchase units at a foreclosure sale in the association's foreclosure. The association can, just not those individuals. I talked about rent demands. Tenant obligations. If the rent is paid, the tenant is prepaid, the tenant needs to notify the association in response to that rent demand notice. Hey, I already paid this through this date. And then the tenant will be obligated to pay the next rental date. And they're only required to pay the amount of rent that they would normally pay to the landlord. It's not you have to pay the full amount. We talk about receivership. It's basically an attorney taking over control of the association because the board is no longer controlling it. This person must be disinterested. So generally speaking, it might not be your actual attorney that you'd prefer. It's someone that gets appointed by a court, and they're appointed to wind up the affairs of the association or get the new board in place to try and keep the association running. We talk about insurance requirements. You need adequate insurance. We don't know exactly what adequate means. But you do need to have a ton of insurance coverage to make sure that if anyone's injured on the property, if the property is damaged, if someone is damaged, or if the directors and officers are sued or the association is sued, that you have that covered. I'm going to skip through a lot of this, but again, it's available to you. Fair housing, basically just keep in mind if someone requests an accommodation of your rules based on the fact that they have either an open and obvious disability or one that they've expressed to you, you need to involve your attorney immediately. If you're not going to just go ahead and allow them to do what they're asking to do. And that includes making changes to common areas to accommodate and give them the same opportunity to use the property that every other member has. We talk about service animals. And again, I've gone through everything I probably can without skipping altogether, but the difference between a service animal and a support animal, a service animal is actually trained and is a dog. And I think a miniature pony is the only other one. And an emotional support animal can be literally anything that a doctor says it is. These are definitions of the term handicap. Then we get into recalls. This is a new topic. It's highly technical. Another one that you're going to want to send directly to your attorney because the procedure is based on the forms that are completed. You need to make sure that the entirety of that form is completed properly. Otherwise, those individual votes don't count and you might not have the recall that you thought you had. Again, a special members meeting to recall the directors can be called by 10% of the voting interests, giving notice of the meeting. It's a member meeting and electronic transmission can't be used to give notice of that meeting. And the alternative to that 10% of voting interest just calling the meeting is a recall by written agreement. Board member can be called by written agreement of a majority of all voting interests. And when we talk about the majority, that's when we get into were the votes proper on their face. In other words, looking at the document itself, is that vote valid or invalid? Within 5 business days, and that's why it's crucial to get to your attorney, after receipt of the written agreements, you need to basically hold that duly noticed board meeting and either say whether you're going to, okay, we're going to certify the recall, meaning the directors named are out and the new ones are in, or no, we're rejecting it. You can file suit if you want to. Okay, challenging. You have 60 days after the recall is deemed certified to challenge yourself being pulled off the board. And finally, if there are 60 or less days until the scheduled election or 60 or fewer days have elapsed since the election that the board member was appointed during or voted in during, the judge generally will not have jurisdiction to hear this. So no petition or court action will be accepted during that time. We talk about terminations. This is going to be a little bit more prevalent due to, again, the new statutes that are being put in place, the new requirements that are being put in place, which overly burden community associations. And so it's just an extensive process that you need to go through. I barely finished almost in time. And so I'm going to stop sharing.
You did really well.
But anyway, Alan, the floor is yours if you want to answer a couple of questions. Now back to you.
Sure, and I've already answered a couple of them in the writing. I was trying to kind of blitz through a few while I could, just to try and answer as many as possible. So I'm going to scroll a little. Are we required to provide a sign language person interpreter for deaf members of the community? Generally speaking, if they request it. Now, keep in mind, when we're talking about people with disabilities, you're not required to accommodate anything until they ask you to. Do you need to provide a sign language interpreter? The answer is maybe. It really depends on whether or not they are asking for it. If they're not asking for it, you don't need to do anything. But if they are actually asking you to do it, then the question is, well, what is that going to cost? Is it a reasonable cost? And is it reasonably necessary to allow that person to actually participate or observe? If you're on Zoom and all your members are on, all your meetings are on Zoom, and there is the automatic transcription function available, that may be all you require rather than a sign language interpreter. But that's the short answer. The longer answer is it really just depends. And if they don't ask for it, the short answer is you don't have to do anything. Does Florida law require an agenda be timely posted in advance of a newly elected board organizational meeting? If yes, 48 hours or 14 days. Yes, and 48 hours. You can do 14 days, it's just not required. So you would want to post that agenda for any meeting timely in advance of every meeting, even if it's the organizational meeting. Now, most communities, or at least some that I represent, will actually have the old board post the meeting and say that organizational meeting is going to take place immediately after the election. That's an option. It's not required. So it just needs to take place as soon as possible. But that 48 hours posted notice is pretty much it. Next question. Do unit owners have the right to participate on the hiring and dismissal of an employee on a self-managed condo? In other words, there's no manager here that's generally helping out in those decision-making functions. It's just the members. The answer is the unit owners have the right to attend. If you are self-managed, it's still employees. So technically, the hiring decision meeting could be closed, and the answer would then be no. If you choose to keep that meeting open, meaning the members are allowed to attend, then they would be allowed to attend. They would be allowed to speak, subject to any written rules and regulations governing member speech at meetings that you've already gone ahead and put into place. If you have no rules restricting it, they can basically do whatever they want as long as it doesn't interrupt the meeting. Okay, that one's answered. Right to speak. Owner says he owns 3 units, so he's entitled to uninterrupted 9 minutes to speak. I often open the floor a second time. Please provide an appropriate response to the 9 minutes request. Thank you. The answer is it's up to a judge. But the bottom line is, my suggestion is, just like any other owner, you have no obligation to put the speech in any particular order. So yes, they're technically entitled to 9 minutes. That doesn't necessarily mean that they're entitled to 9 uninterrupted minutes. It could be, especially if you put directly in your rules and regulations governing how these meetings operate, it could very clearly say anyone that owns more than 1 unit will get the chance to speak for each unit, but it is not guaranteed that they will get the chance to, use their entire time uninterrupted. So that's my answer. It's up to a judge, it's up to the board, but I would put rules and regulations governing the issue directly in effect so that it's clear. Even if it's clear that you're doing it for the purpose of restricting this one person, there's nothing they can do about it because they're the association's rules that are going to be applied uniformly across the board. Our agenda only lists president's report, VP report, treasurer report with no detail. How do members speak to this? Well, that depends whether you have, again, rules and regulations governing member speech at the meetings. If you don't, then they can speak however they want. How do members speak if you have rules and regulations in place and your agenda is still this, I'll call it sparse? The problem is you're not really giving notice of what anything is going to be discussed. So you might not really be able to do business. I mean, what I would suggest is at least put in new business and old business and approval of the minutes from the previous meeting. I think those are kind of minimal things to put in. And I hope that all the people that are asking these questions are still here, but I hope everyone else that is still here is getting something out of this as well. So that would be my answer. Put it in the rules and regulations and flesh out your agenda a little bit more with a little bit more clarity, at least as to vague assertions of, we're going to discuss general business, we're going to discuss old business, we're going to approve the prior minutes. Can you give employees monetary Christmas gifts out of operational funds if it's in the budget and no one has challenged it? Generally, I don't have a problem with that. I've seen some communities that do that. Some of them will take the money out of their own pockets instead of association funds. I think either way is okay, as long as you're giving very clear notice to the members that this is in the budget, that it is being documented properly, and it's not just, hey, here you go. When a board member sells their home, how soon are they off the board? At closing, ? Generally speaking, yeah, as soon as they no longer own a unit in the community, unless, like I mentioned during the presentation, your governing documents say you don't have to be a member. At that point, they would really have to resign, or the next election would have to take place before they're actually off the board. Does Florida law require the agenda items appearing on our board's regular meetings be written in the manner where a reasonable person could understand what's to be discussed, or can it be cryptic? I would say just a couple of words, like you mentioned, is probably fine. It doesn't require that you sit there and put a paragraph for each item of what you're going to discuss. You do need specific notices regarding assessments, special assessments, things of that nature. But if it's just your general meeting and you're going about business as usual, there doesn't really need to be any specificity in the agenda. Can just the president appoint a person to fill a vacancy? No, the board needs to vote on appointing a person unless the entire board has delegated that authority to the president. So generally speaking, you need to have a board meeting and there needs to be a vote to appoint that member. Or again, you can have, that written resolution or written consent if the vote to have that person take the position is unanimous. I actually dealt with something similar to that just a week ago. The party that lost challenges the election, who pays? The community. If the party that lost challenges the election, the community as a whole, the association through assessments is going to pay for everything. And so what you're going to be looking at is the community is going to pay the cost of the lawsuit during the lawsuit. If they sued the association, it's possible that some insurance carrier might cover it. So the association's expense out of pocket is limited to some extent to basically, your insurance deductible. If you're defending yourself through counsel, for example, through our firm, that would be something that, the association pays for it throughout the course of the lawsuit. And then hopefully the association prevails. And at that point, a judge might award all of the attorney's fees and costs that the association spent back to the association and basically says, hey, plaintiff, you shouldn't have filed this lawsuit. You lose. You not only pay your attorney's fees and costs, but also you owe the association all this money. Now, the problem is the association gets that judgment that says plaintiff owes them this amount of money. That's a nice piece of paper until you do something to collect on it. That judgment doesn't really mean much other than, hey, this person owes you money. It's just like, well, we levied a fine. Okay, well, that's great. Until you actually do anything about it, it doesn't matter that they owe you the money. So I always recommend when you get that judgment, record a certified copy, etc. You basically want to make that a judgment lien, not only with the state of Florida, but also within the county, so that anytime they go to sell, get a mortgage, and that's not only a lien against that particular lot or that unit in the case of a condo, it's actually a lien against all property that this person owns in the entire county. And if you know that they own property elsewhere, you can record it there as well and create a lien against any property there. So I recommend going an extra step, but that's only after you prevail. So that went way beyond answering the question, but hopefully it helps someone that got a judgment and didn't know what to do. What are the...
Let's do a couple more. Let's do two more. Is that okay?
Yeah, absolutely. What are the statutory sunshine requirements for non-statutory committees created by the board? It's exactly the same as any other committee. Basically, you need to give notice of all committee meetings where you're going to spend association funds or make final decisions on behalf of the association. And keep in mind, committees can make decisions just like the board if they're delegated that authority. So, we talk about sunshine requirements. Again, sunshine law doesn't apply, but there are similar requirements, and it does need to be a noticed meeting. If your governing documents are silent as to what notice is required and what meetings can be exempted from that notice, they all require that notice if you're voting to spend association funds or make decisions that are final decisions on behalf of the association. Let's see. Can the board meet in an executive session to discuss the performance of its management company's assigned CAM with said CAM? Generally, no, because that is something that is open to the membership. Now, if the board is considering, terminating and is consulting with its attorney as to whether or not to terminate under the circumstances, generally speaking, that manager wouldn't be invited to the meeting. So that's different technically from the question that was asked, but it is something that should be considered. If you're having a meeting with counsel, that can be closed to the members. And when you say executive session, I presume you mean that not all the members are allowed to attend. There's no such thing as an executive session, but it could be something that is closed if that manager is not involved. If the manager is involved and it's a discussion regarding performance of management, technically there's really no basis to close that meeting to the members and hold it as an executive session or a closed meeting. Okay, you said two, I did two. Jeff, it's all you.
We appreciate that.
And
Wonderful
I apologize
job.
to anyone that we didn't get to. I have 20 additional questions that I wasn't able to get to. I tried to get to as many as possible and fly through really quickly, but we just had way too much to cover today to do it in 2 hours.
That's about 30 more questions than I thought we would answer today. So fantastic job.